So this statement, Mr. Vigneault, and I'm going to direct my questions to you, but if your colleagues have things they'd like to add, please do. This statement that your understanding that the Emergencies Act definition of threat to the security of Canada was broader than the CSIS Act. Where did you get that understanding? I know Mr. Cameron said maybe we'd hear about it later, but I'd like to hear about it now.
So I asked for legal interpretation.
Okay. You asked the Department of Justice?
I did.
Okay, thank you. Now, I just want to, if we can scroll down a little bit more. This is maybe a grammar or a language point that I just want to understand. It says, he advised the Prime Minister of his belief that it was indeed required to invoke the Act. Is that it referring to the government, that the government was required to invoke the Act, or that the Prime Minister, or?
I'm not sure.
Okay, but your view was that based on this broader understanding of threats to the security of Canada, the Act should be invoked.
Yes.
Okay, so I just want to go through, and Mr. Cameron went through some of the timeline here. You had an interview with Commission Counsel on, I believe it was August 29th. And in that interview, you noted that you had only learned that the Emergencies Act referred to the CSIS definition of threats to the security of Canada when the government started to explore the possibility of invoking the Act. Is that right?
Yes, that's accurate.
Okay. And then Commission Counsel prepared a summary of that meeting, that interview with you and your colleagues. We've seen that, and that was produced earlier. And then you had this in-camera proceeding that took place. And I understand that again, you confirmed that it was CSIS's view that the definition of threats to security of Canada in the CSIS Act was not met during the convoy?
Yes.
Okay. And then under examination from the Government of Canada, this information that you advised the Prime Minister of your view that the Act should be invoked was disclosed for the first time. Is that right?
Yes, I believe it is, yeah.
So you said in your initial witness statement that you felt it was important to communicate at the IRG and to Cabinet that under CSIS's analysis, there wasn't a Section 2 threat.
What I wanted to be very clear, Mr. Commissioner, is that because it was very dynamic environment, very, a lot of moving parts, as we say. And I wanted people to be clear about how CSIS, we were analyzing the situation. And so people were talking about using different words in the media, everywhere. And we just wanted to bring a level of clarity. So that's why we said our assessment was very dynamic, and we continued to assess. But throughout that period, we wanted to make sure that people did not misinterpret based on everything that was being mentioned, that CSIS, we saw a threat to national security based on our act. So that was the purpose of us being very deliberate about that approach.
Okay, I guess, I mean, you understand that one of the purposes of this commission is to assess whether the act was properly invoked. Sorry, can you just answer audibly?
Yes.
Thank you. And I guess I'm wondering why you didn't think it was relevant when you met with Commission Counsel in August to note that you had in fact advised the Prime Minister that you believed the act should be invoked.
I think there probably two reasons, I would say. One is that very simply the question was not asked, and so just when you go through the dynamic process of the interview, so it did not was not specifically asked. But there was also at that point a lack of clarity in my head about what was still a cabinet confidence and what would be what I was able to say as a participant in cabinet meetings. So that was further clarified throughout that period, and that's why I think. Again, Mrs. Wiebel, you mentioned, the nature of this commission. as a senior official in government, we're never allowed to speak about cabinet confidences. We're never allowed, in the case of CSIS, to produce, a number of the information that has been, put in front of in public for Commissioner, for Canadians to see. Normally, that will not be public. So just needed to ascertain, what were the limits of what we're able to do. And when it was clarified with me that indeed I was able to speak to that, I did.
Okay, but when you met with Commission Counsel in August, you felt that you didn't feel that cabinet confidence prevented you from advising that you had advised cabinet and the IRG that you did not believe there was a threat within the meaning of the CSIS Act.
That had been clarified with me, yes.
Okay. Because I would put to you that those two pieces of information are really two sides of the same coin, that if one is not subject to cabinet confidentiality, the other one also would not be.
I understand that analysis, but I would say that just back to what I said, we never discussed cabinet confidences, and the information, the way that the information was communicated to witnesses in terms of what would be possible to disclose and not in terms of cabinet confidences just became clearer with the passage of time, between August and our ex parte interview.
Okay, thank you. I don't know if you had an opportunity to review the testimony given by Ms. Thomas, the National Security and Intelligence Advisor.
I briefly saw some of the key extract, yes.
Okay. So one of the things that Ms. Thomas said was that that the CSIS definition of threats to the security of Canada is quite narrow. Do you agree with that it's a narrow definition?
I would say that the CSIS Act was enacted in 1984, and I think that the world has evolved considerably since then, and that looking at the threat environment today is indeed requires probably a new look, modernizing a view of this. That's one thing. And the second thing is that we also, through jurisprudence, through federal court rulings, commission of inquiries, and review bodies who have access to all of our information, that understanding of the Act was very much more clarified, and so very with a lot of specificity, if you want, in many aspects. And so between experts at CSIS and the OJ Council, I think there is a very specific interpretation of the Act, which is in this specific case of the Commission different than the Emergencies Act.
Okay, so and I mean, you understand, of course, why, and I think you've alluded to this in other statements that you've made here today and in your witness statement, that there should be a high threshold before our intelligence services start surveilling or targeting Canadians. Would you agree with that?
Yes, I do agree.
Okay. The holding or expressing of unpopular political views should not be enough to engage CSIS's mandate.
Absolutely not. And I would say that there is an expression that we use, which is awful but lawful. And that means that some of the opinions expressed verbally or online, are not by default, even if they can be extremely violent, are not by default something that would allow or necessitate CSIS to investigate.
Okay, and do you understand why? Now, I know you take the view that the definition in the Emergencies Act is broader, but would you agree that the threshold to invoke the use of the Emergencies Act should also be a high one?
I would say that with anything, any exercise of power by the state, there is a high threshold. I'm not a legal expert to say, what should be the threshold of the Emergencies Act. So
okay, but you understand that the Emergencies Act allows the government to rule by executive order for a period of time.
I do.
Okay, and that the public order emergency section of the Emergencies Act allows those orders to let the government assume control of public utilities, for example.
Yes.
And it allows the government to direct individuals to render certain services, like was done in this case with the tow trucks.
That's my understanding. But again, I do not want to give the Commission the impression that I'm an expert on the Emergencies Act.
Okay. And you understand that it can prohibit travel to, from, or within any specified area? That's one of the things that the public order emergency section allows.
I would say yes, with the same caveats
Caveat.
I've just provided. Yes.
Okay.
Okay, you're now out of
All
time,
right.
so if
Thank
you
you.
could wrap
No,
up, please.
just one last question. The placemat that you were taken to by Ms. Khan, that talked about the IMVE, the nature of ideologically motivated violent extremism. Two of those sort of elements were willingness to kill or a willingness to engage in serious violence. Would you agree with me that without those two elements, you just have people who care a lot about something and want to make a change?
I'll answer that question. That's exactly why we developed the criteria as to what should be looked at in this space, in this IMVE space, was to ensure that those criteria were met before we open an investigation.
Thank you.